be a written copy provided to you as well. And so I'll begin right there. You will have a written copy of the instructions I'm about to read to you, and you may refer to them during the trial if you wish. Since no one can predict the course of a trial, these instructions may change at the end of the trial. At the close of the trial, I will provide you with a final copy of the instructions for your use during deliberation. Now I will explain some of the legal principles that you will need to know in the procedure that we will be following in this trial. As stated, the defendant is charged with the crime of assault with intent to do great bodily harm less than murder. To prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant tried to physically injure another person. Second, that at the time of the assault, the defendant had the ability to cause an injury, or at least believed that he had the ability. Third, that the defendant intended to cause great bodily harm. Actual injury is not necessary, but if there was an injury, you may consider it as evidence in deciding whether the defendant intended to cause great bodily harm. Great bodily harm means any physical injury that could seriously harm the health or function of the body. The intent with which an assault is made can sometimes be determined by whether a dangerous weapon was used. A dangerous weapon is any instrument that is used in a way that is likely to cause serious physical injury or death. Also, the prosecutor must prove beyond a reasonable doubt that the crime occurred on or about February 26, 2022 in the city of Bad Axe, County of Huron. As stated, a person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair and honest doubt, growing out of the evidence or lack of evidence. It's not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. And this is the trial procedure. First, the prosecutor makes an opening statement where he gives his theories about the case. The defendant's lawyer does not have to make an opening statement, but he may make his opening statement after the prosecutor makes his, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents his evidence. The prosecutor may call witnesses, testify, may show you exhibits as well, like documents or objects. The defendant's lawyer has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of his evidence, the defendant's attorney may also offer evidence, but again, does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of defense witnesses. After all the evidence has been presented, the prosecutor and the defendant's lawyer will make their closing arguments. Now, just like the opening statements, they are not evidence. They are only meant to help you understand the evidence and the way each side sees the case. You must base your verdict only on the evidence. My responsibilities as the judge in this trial are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the only ones who will decide this case. Your responsibility as jurors is to decide what the facts of the case are. Again, that is your job and no one else's. You must think about all the evidence and all the testimony, and then decide what each piece of evidence means and how important you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of the case are is to decide which witnesses you believe and how important you think their testimony is. You do not have to accept or reject everything a witness says. You are free to believe all, none, or part of any witnesses or any person's testimony. In deciding which testimony you believe, you should rely on your common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any bias or prejudice you may have based on the witness's race, national origin, ethnicity, gender identity, or sexual orientation, religion, age, socioeconomic status. There's no fixed set of rules for judging whether you believe a witness, but it might help you to think about some of these questions. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does a witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyers? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias, prejudice, or any personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in this case? When it is time for you to decide the case, you are only allowed to consider the evidence that was admitted in this case. Evidence includes only the sworn testimony of witnesses, the exhibits admitted into evidence, and anything else I tell you to consider as evidence. The questions the lawyers ask the witnesses are not evidence, only the answers are evidence. You should not think something is true just because one of the lawyers asks questions that assume or suggest that it is. I may ask some questions of the witnesses myself. Now, these questions are not meant to reflect my opinion about the evidence. If I do ask questions, my only reason would be to ask about things that may not have been fully explored. As always, if you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately and let the court know. During the trial, the lawyers may object to certain questions or statements made by the other lawyer or witnesses. I will rule on those objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes, the lawyers and I may have discussions outside of your hearing. Also, while you are in the jury room, I may have to take care of other matters that have simply nothing to do with this case. I ask that you please not pay any attention to those interruptions, but I promise you I will try to keep them to an absolute. As I stated as well, you must not discuss the case with anyone, including your family or friends. You must not even discuss it with the other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. As stated, you must not talk to the defendant, the lawyers, the witnesses, or anyone else who may be connected to this case. This means you may not speak to these individuals, even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to the case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell that person to stop. Explain that you are a juror and you are not allowed to discuss the case. If they continue, leave and report the incident to me or court staff as soon as you return back to court. When the trial is over, these restrictions no longer apply, and when the trial is over, you may, if you wish, discuss the case with anyone. The restrictions I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it is crucial that jurors are not influenced by anything anyone outside the courtroom. Under the law, the evidence you consider must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because information obtained outside the courtroom does not have to meet these do not have these safeguards, it could give you incorrect or misleading information that may unfairly favor one side. These restrictions start now and continue until I discharge you from jury service. It is your duty, that is, as a juror to decide this case based solely on the evidence you see and hear in the courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you are not to read, watch, or listen to, or receive any information, including opinion or commentary about the case, whether newspaper, TV, radio, internet, or other social media platforms. You also must not research any aspect of the case during the trial. This means research using cell phones, computers, or other electronic devices to search the internet, as well as traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including experiments or investigation using internet, cell phones, computers, or other electronic devices. You must not visit the scene of any event at issue in this trial. If it is necessary for you to view or visit the scene, court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge you may have. You must not share any information about this case by any means, including cell phones or social media. This means that even if you are not discussing the case with someone else, you may not post any information about the case on social media websites or in any other manner. If you discover that a juror has violated these instructions, please report it to court staff. As you walked in, you may take notes because there were no pads, as I stated, and pens as well. You may take notes during the trial if you wish to, but of course you do not have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide on your verdict, you may use the notes to help you remember what happened in the court. If you take notes, do not let anyone except the other jurors see them during deliberations. Your notes will not be examined by anyone, and when the jury service concludes, your notes will be collected and destroyed. So, for instance, if you do decide to take notes during the course of this trial, when we take a break, simply take your notepad, place it face down on your chair. That assures that no one will be able to see the date of your notes. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits allowed by law. Finally, I may give you more instructions during this trial. And after the trial, after all the evidence has been presented, that is, you will hear the lawyer's closing arguments. Following the closing arguments, I will give you additional instructions about the law, the rules of law, that is, that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law that you must follow. After my final instructions, you will go to the jury room to decide on your verdict. A verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. Most important, it is important for you to keep an open mind and not make a decision about anything in the case until you go to the jury room to decide on your verdict. You must not let bias, prejudice, or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. So take the time. You need to test what might be automatic or instinctive judgment and to reflect carefully about the evidence. I caution you, again, to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusion about the case individually, but you should do so only after listening to and considering the opinions of the other jurors, which they may have different backgrounds or perspectives. That concludes my instructions for this morning. At this time, it's time for opening statement. Mr. Pahani, you may proceed.
Thank you, Your Honor. Ladies and gentlemen, once again, good morning. We're getting closer to good afternoon, but my name is Alexander Pahani, and again, I'm the Assistant Prosecuting Attorney for Huron County that's assigned to the case today. So this opening statement, as the judge pointed out, is kind of a preview of coming attractions, what I expect that you will see during the course of this trial today about what happened back on February 26th of 2022. Now, first of all, on behalf of the elected prosecutor, Tim Murkowski, we thank you for your service today because it is important. It's the most important aspect of our criminal justice system, the job that you are going to do sitting in those chairs today as the finder of fact. As the jury, you are the finder of fact. You have to determine, based upon everything that you hear today, what actually happened back on February 26th of 2022. And that's a hard job because none of you were there. But during the beginning processes, during the voir dire, you explained or you agreed that you could listen to the evidence that is presented today, and you could determine the credibility of the people that you hear from today, and that you can use your experience and what you hear today to make a determination about the facts of this case. Here's what I expect that you will hear today during the course of the trial. We'll start with Officer Brianna Emming. She was working patrol on February 26th of 2022 for the City of Bad Axe Police Department. She received a call about an assault that occurred in the City of Bad Axe, and the individual that had been assaulted was currently at the McLaren Thumb Region ER. So she responds out to the ER, where she makes contact with Nathan Wasowski. And she talks to Nathan for a bit, and she'll testify to the effect that he wasn't entirely upfront and cooperative with her. He didn't seem like he wanted to explain all of the details of what had put him in the emergency department that day. She talked to him for a bit. She took some photos of his injuries, and then she left. The case was then turned over to Detective Sergeant Kevin Knobloch, also of the Bad Axe Police Department, because whenever a case needs further investigation, it moves to the detectives. They're the ones who do all of the follow-up work when a patrol officer takes a case that's not open and shut, something easy that can be taken care of in one visit. And that's why Detective Sergeant Knobloch got involved in this particular case. After Officer Emming testifies, you'll hear from Dr. Michael Remley. He is the emergency department physician that was on duty at McLaren Thumb Region back on February 26th. He will testify that he examined and treated Nathan Wasowski, and that he will go into detail about the injuries that he was able to determine through the tests and examinations that took place in the ER that day. After that, you'll hear from Detective Sergeant Knobloch, because the investigation, as it continued, he needed time to interview witnesses to determine how best to proceed in his investigation. And he'll explain that to you once he's on the stand of how that kind of unfolded from the time that Officer Emming got to the ER to the time that the case ended up on Detective Knobloch's desk. But he'll testify that after his interviews with the victim, after his interviews with a witness, he was able to determine the type of weapon that was used in this particular assault. And so he will testify that he got a search warrant, went to the defendant's home looking for this particular weapon, and he found it. And you'll see it. After Detective Knobloch testifies this morning, you'll hear from Morgan Weisenbaugh. She's one of the individuals that was at the defendant's house the evening all of this took place. So one of the witnesses. And you're going to get to hear how the story kind of unfolds, because it was some young people who went out to a bar in Bad Axe. There was some drinking. They go back to the defendant's house. Everything seems to be going okay for a while until about 4 o'clock the following morning. And then Ms. Weiserbaugh, I expect, will testify that she heard a commotion, a ruckus of some sort. And she came out to find the defendant and the victim wrestling. The wrestling match came to an end after a short time. And then she will testify that she watched the defendant break off that fight, go pick up a weapon, a metal pipe, and proceed to assault the victim with it repeatedly. Then, ladies and gentlemen, you'll hear from the victim himself. Now, again, everybody had been drinking that night, and so memories are a little bit fuzzy. And as Mr. Garski alluded to in Wichert, these people are friends, and they may not want to tell you everything that happened. And that's why your job is so important here today, because you're going to have to take the testimony that you hear and decide what actually happened that day from people who might not want to be here today for one reason or another. But Mr. Lisowski will testify that he was in a wrestling match with the defendant, just hands, wrestling, grappling about in the house. It ended. He tapped out. He said, "I'm done." And then the defendant went and picked up a metal pipe and started beating it. So, ladies and gentlemen, at the end of the day, again, you'll get to see those elements for assault with intent to do great bodily harm, less than murder. And you will find that through the testimony that you hear today, through the exhibits that you see today, that the defendant did indeed commit this crime. And the issue of self-defense may come up. If it does, I want you to take into consideration, again, all of the facts that you see during the people's case. Because Mr. Lisowski never had a weapon. He was wrestling with the defendant. That's what he'll testify. No weapons were involved until the defendant went and picked one up and started using it. And that, ladies and gentlemen, is self-defense. And so at the end of the day, you'll have no choice but to render a guilty verdict on the charge of assault with intent to do great bodily harm, less than murder. Thank you, ladies and gentlemen.
Mr. Karski, would you like to make your opening statement?
Yes, Your Honor.
You may proceed. You can show that podium.
Connor, it was a long day at work. He was working, just picked up some extra hours. Normally doesn't work a night shift, but decided to work a night shift that night. Just got off about a 6-7 hour shift. Goes to the bar where he's gonna grab a 6-pack, take home. When he gets there, he sees some friends. He's got a friend Jimmy, Morgan, Josh, and with them is Mr. Wasowski. They all decide, all right, let's go back to Connor's house. So everybody goes back to Connor's house. They get there, obviously he picked up the 6-pack. Everybody's drinking, they're talking, they're having a decent time. At some point, Jimmy leaves. Now, Jimmy was Mr. Lisowski's ride. Why he left, why Mr. Lisowski didn't go with him, couldn't tell you. He would have to tell you. But he, for whatever reason, decides he's gonna stay. As they're sitting there in the living room, Josh decides, all right, I'm tired, I'm going to bed. So he goes to bed. And that leaves Mr. Lisowski, Connor, and Morgan. They're in the living room. They're playing some video games. They're having a couple of beers. Morgan stays in the living room. But while they're sitting in the living room playing, Mr. Lisowski keeps bringing something up. He's talking about how Connor had jumped him in the past and that he had to chase him off. And everyone's like, "What are you talking about?" He's like, "You fucking did it." And they just kind of, whatever, they blow it off. They think that's the end of it. And then at some point they decide, let's go play cards. So the way this house is set up, you walk into the front door, you go left, and there's an open area for the living room. Straight back is a little dining area where there's a dining room table, and then there's the kitchen to it. So Morgan stays in the living room. Mr. Lisowski and Connor go into the kitchen. They're getting at the table. They're getting ready to play some cards, and the argument breaks up again. Like, just fucking say it. You know you did it. And I don't know what you're talking about. And it's at that point, Mr. Lisowski gets up, stands over top of him. You know you fucking did it. I don't know what you're talking about. And that's when he grabs Connor while he's in his seat, The two start to wrestle. He's able to lift Connor out of the seat as they're wrestling. They go into the table. Table breaks. They're wrestling back and forth on the floor. This is when Morgan comes in. What's going on? Connor has him pinned enough. Dude, stop. Has him pinned on the ground. Stop. Nate stops. Connor gets up. He walks up and says, dude, you got to get out of my house. I think he tells him, dude, you need to get the fuck out of my house. He walks out, down, out of the dining room area, down a hallway, and we're talking of just little narrow standard house hallway. There's a door to the bathroom, and then there's two doors to the bedrooms. He's going there because that's where Josh is. Josh is asleep through all this. He's going in there to get Josh up to say, dude, you gotta help me get him out of here. As he's going in there to get Josh up, he hears, I'm gonna fucking kill you. So right next to him is this training bat. It's not a baseball bat. It's not a little pipe. It's one of those bats, if you ever played softball or if you ever played baseball, it's a long, skinny bat. It's designed so that you can practice on getting that sweet spot. You know, it's a lot skinnier so that you're not used to hitting with that big barrel. So he picks up this training bat and he stands there. The next thing he sees is Nate comes around the corner. Nate looks at him, sees he's got the bat, gives him the look and charges at him. So it wasn't like Connor went and got this bat and said, oh, hey, you're on the ground. I'm gonna start beating you with it. He goes to get help, to get Josh, to get him up. And that's when he hears that I'm gonna fucking kill you. He grabs the bat, he's standing there with the bat, and Nate still charges him. Mr. Lasecki still charges him knowing he has the bat. They struggle, as they struggle, the hit goes up, which is gonna cause the damage, and I'm sure you'll see the pictures. He took a good blow to the top of the head, which knocked Mr. Lasecki down. He is still grabbing, trying to pull Connor to the ground, because that's where he would have the advantage. If this fight and get to the floor, he would have the advantage. And that's when Connor had no other option. He's in his house. It's not like he can leave and go to his home somewhere. He's in his own home. He has no duty to retreat, but he does. He leaves. He leaves the first fight. He goes down the hall. He tries to get Josh to get some help. Like, hey, we gotta get him out of here. And Nate is still hell bent on getting his fight. He ends up hitting him with the bat until he stops fighting. The second Mr. Lasecki stops trying to grab him, trying to tackle him, it's done. He doesn't continuously beat him once he has the upper hand. He uses the bat only to defend himself. After that, that's when Josh and Morgan now come to the hallway. Morgan takes Mr. Lasecki into the bathroom. Mr. Lasecki doesn't call 911. He doesn't call for help. He's trying to clean himself up. He's in there for a couple of hours. After he comes out of the bathroom, he's still not done. He again charges Connor. Connor's in the living room. He charges him again, looking for a fight a third time. This one doesn't last very long. Connor immediately gets him to the ground. Morgan grabs him. They go back into the bathroom. Connor retreats to the basement. Eventually, a couple hours later, Mr. Lasecki leaves. Doesn't go to the hospital. He goes home. I believe it was Morgan gives him a ride home. He cleans himself up. He waits a couple hours. And then ultimately, he goes to the hospital later in the day. And he isn't forthcoming at all with the officers when they come. He tells them that he did nothing, never touched anyone. He was just assaulted blindly. But doesn't want to say who it is, doesn't want to say who did it, because he's been in jail and he doesn't want to put anybody through that, is what the story he gets.
Objection, Your Honor.
Council.
It wasn't until a week later that all of a sudden now he wants to press charges. And now that he wants to implicate Connor in all this. But when you look at the facts, when you look at how it happened, how the facts support the injuries, how the facts show and what the witnesses are going to tell you, there's only one verdict that you can have right now. Connor acted in self-defense and he is not guilty.
Members of the jury, we are going to take a short recess. Please follow the bailiff into the jury room. We will call you back in momentarily. All rise, please. Please be seated. Members of the jury have been excused and remain on the record. Mr. Bahani, you placed an objection during the opening statement. You may verbally now state your objection.
Thank you, Your Honor. The people at this time move for a mistrial based upon Mr. Garsky's comment in his opening statements that the victim stated that he had been in jail at some point and did not want to put the defendant through any sort of similar actions. Your Honor, that's facts that have never been placed into evidence in this case. In the preliminary examination, no body cam video was ever presented. Even if body cam video where the defendant or where the victim stated that would have been admitted, that piece would have been redacted because any type of criminal history comment as to the victim in this case is inadmissible. Mr. Garsky knows that, and this is an intentional mistrial on his behalf.
Let's invoke 609, but we're not there. It's not even in evidence yet. Mr. Garsky, your response.
Likewise, Judge, it's an opening statement. It's what I anticipate the evidence would show. Of course, it's not evidence. We haven't taken any evidence yet. It's my understanding that that's what it's in the reports. It's exactly what he tells to Officer Emming. And the people through their entire voir dire have made it that he is too afraid to name Mr. Wichert. That's been the theory of their case. I'm allowed to attack that theory. And one of the things that we get to show that will be in, when you look at the considerations of self-defense, is other violent acts by the victim that Mr. Wichert was aware of, and whether or not he was justified in using self-defense. And if that's what the reference to him being in jail was about, that fully comes in too.
Your Honor, by that very argument, then I could stand up in my opening statement and start talking about Mr. Weichert's prior criminal activities, the fact that he's been in jail, the fact that he has charges pending, the fact that he's on probation for another charge. It's the same rule, Your Honor. He can't bring it up, and he knows he can't bring it up. He can attempt through MRE 609 to bring it up on a direct or cross-examination of the witness when he gets on the stand, but he cannot enter those facts into evidence or put them before the jury prior to any testimony taking place whatsoever. He's already impugned the victim in this case.
No, Your Honor, obviously we are allowed to discuss his history that Mr. Wichert is aware about in terms of whether or not he was justified in using self-defense. Obviously, he's allowed to question any witnesses that he wants, and this is, again, is not evidence at this point because it's just an opening statement.
Presuming he takes a witness case.
Who?
The client.
Yes, he will. I fully anticipate he's going to testify.
Final comment.
How the victim's prior criminal history could possibly be used to assert a claim of self-defense is beyond the people. How does he know what he knows or what he purports to know? He's put this in front of the jury and it's improper, Your Honor.
Thank you. Well, the court finds it improper as well at this point. But this is a motion now for mistrial. Mistrial should only be granted for an irregularity that is prejudicial to the defendant's rights and means the defendant's ability to get a fair trial here to the people, because it's been brought up that the alleged victim has been in jail as well. Mistrial should be granted only where the error complained of is so egregious that the prejudicial effect can be removed in no other way. It's citing People versus Gonzalez, 193 Michette 263. Before ordering a mistrial, the court must on the record give each party an opportunity to comment on the propriety of the order, to state whether the party consents or objects, and to suggest alternatives. Mistrial can be declared because of manifest necessity under the Mehall case. That People versus Mehall 454 Mich 1. What the court has heard is, again, a reference and opening statement that the alleged victim has been in jail. Now, we don't know if it was for conviction. I don't even know at this point. But the court has to look at whether or not the prejudicial effect is so egregious it cannot be removed in no other way. Again, I find it improper. Now, clearly, if there's a self-defense argument that's brought during the course of the trial and the rules apply, that's another thing, but we're not even to that point yet. I don't find at this point that it's grounds for a mistrial. However, I do find it improper. I don't know of any other curative instruction, because if the court gives a curative instruction, it kind of rings the bell again. I can't unring the bell, Mr. Pahani. So do you have any other suggestion at this point other than to keep moving forward?
Your Honor, I've just never seen anything like this in my years of practice. I'm disgusted.
I really bring the jury back in and call it first witness. People call it first witness. All right. Please be seated. How did they call you?
Thank you, Your Honor. Call Officer Brianna Emming to the stand.
Officer Evans? Please stop, raising your right hand, facing the court administrator.
Solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Once seated, you can speak loudly and clearly, so members of the jury and everyone can hear you. Honey, you may proceed.
Thank you, Your Honor. Good morning. Can you please state your name for the record and spell your last name for the court recorder?
Brianna Guza, Guza, formerly known as Brianna Emming, Emming.
Thank you, Officer Guza. How are you employed?
For the Bad Axe Police Department.
Okay. And to what division are you typically assigned when you're working for the Bad Axe Police?
Road patrol.
Okay. And were you working as a road patrol officer on February 26th of 2022 at around 2 in the afternoon?
Yes, it was.
Did you respond to a call for service at McLaren Thumb Region Hospital?
Yes, it is.
What was the nature of that call for service?
It was a assault victim seeking treatment.
And did you make contact with anyone upon your arrival at the hospital?
I did. I spoke to the doctor at the front desk.
Do you recall who that was?
Remley, I believe.
And did you ultimately speak to the victim of the assault?
I did.
And who was that?
Nathan Lasowski.
And what observations did you make of Mr. Lasowski in the emergency department?
He was clearly injured to his face and bleeding from his head.
Now, was Mr. Lasowski cooperative with your investigation?
Not completely.
Did he tell you when the assault took place?
A rough idea.
And when was that, if he said?
3 a.m. that morning.
Did he indicate how he was assaulted?
He thought with possibly a pipe or a ceramic tool.
Did he assist you in any way in identifying the suspect?
No.
Did you take any photographs as part of your investigation?
I did.
May I approach the witness, Your Honor? Officer Guza, I have what's been marked as people's proposed exhibits 1 through 9. If you could just flip through each one of those and tell me when you're done looking through each.
I am finished.
Officer Guzzo, do you recognize those photographs?
Yes.
Did you in fact take those photographs?
I did.
And what do they depict?
They depict Mr. Lasowski's injuries at the hospital that day.
And are those a fair and accurate representation of the visuals that you saw in the emergency department that day?
Yes.
The people moved for the admission of proposed 1 through 9. Your Honor.
Mr. Karski, if you had the opportunity.
Hey, retrieve it real quick here. No objection to the admission, Your Honor.
Thank you. 1 through 9 are,
The people published to the jury, Your Honor.
yes.
Officer Guzzo, I'd like to go through each one of People's Exhibits 1 through 9, and if you can just explain what these photographs are as they appear on the screen. Here's People's Exhibit 1. What is that?
The lacerations to the top of the head.
And is that Nathan Lasowski?
It is.
This is People's Exhibit 2. Can you explain what that is?
The injury to his nose showing the swelling.
This is People's Exhibit 3. Can you explain that one?
Although dark, there is a laceration to the back of his head.
This is People's Exhibit 4. Can you explain that one?
This one shows the injury to his nose again and the red marks on his forehead.
This is People's Exhibit 5. What are we looking at here?
These are the pictures of his back, shoulder area of where the pipe or ceramic pool hit him.
This is People's Exhibit 6. Can you explain that one?
That's another photo of the victim's right side.
This is People's Exhibit 7.
And that's the left side of his injuries.
People's Exhibit 8.
His left shoulder,
And finally, People's Exhibit 9.
that's his full back, showing the length of the injuries.
What was the next step in your investigation? After you took these photographs and met with Mr. Lasowski in the emergency department, what did you do next?
I handed him a business card with the report number in case he ever changed his mind or remembered any more details of the incident to follow up with Detective Knobloch.
And is it fair to say that you turned over your investigation to Detective Knobloch?
I did.
Thank you. I have nothing further at this time, Your Honor.
Thank you. Cross-examination, Mr. Karski.
Did he tell you what started the assault? Did he ever admit to you about striking Connor?
No.
In fact, he told you that he never touched him.
Right.
And all the injuries that you saw, they're all of the upper back, head, and face.
Correct.
At this point in time, did he tell you who assaulted him?
No.
Did he ever tell you why?
No.
Never told you he was scared of somebody.
No.
Did he admit to drinking it?
Yes.
Did he say how much?
No.
Did he admit to using any other drugs?
No. Not that right.
Did you ever give him a PBT?
No.
And about what time were you called? Called to the hospital?
Approximately 2 p.m.
2 p.m. And did he say what time this incident happened?
He gave an estimation of 3:30 that morning.
What, 12 hours prior?
Give or take.
Did he give any names of anyone that was there?
Negative. No.
Negative. No further.
Redirect.
No redirect, Your Honor. We'd ask that the witness be excused.
Any objection, Mr. Karski?
No, Your Honor.
You may step down. Thank you. Honey, your next witness.
People call Dr. Michael Remley to the stand, Your Honor. Thank you.
Oh, wait, council. Wait. Down this way.
Oh, he's on his way, Detective.
Doctor, would you please step up to this witness stand? Before having a seat, sir, would you please stop raising your right hand facing the floor? I should say, according to.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
I do. Please be seated. Sir. Once seated, speak loudly and clearly so everyone can hear. How do your witness, you may proceed.
Thank you. Good morning still, sir. Can you please state your name and spell your last name for the court?
My name is Dr. Michael Remley, Remley.
And what type of doctor are you, Dr. Remley?
I'm a board certified fellowed emergency medicine physician.
And where do you typically practice?
I am the site director for McLaren Arrow region and McLaren Thumb region.
And were you working as the emergency department physician at McLaren Thumb region on February 26th of 2022 at about 2 p.m?
I was.
Did you have opportunity to examine and treat an individual by the name of Nathan Lasowski?
I did.
And what was Mr. Lasowski's chief complaint upon presenting to you at the emergency department?
Reviewing my notes, and from what I remember, the patient was at a party the night before, approximately 3 o'clock in the morning. He was allegedly assaulted with a metal or a ceramic pipe, is what he told me at the time. He was able to, at one point, at least what he told me, was get the pipe away from the person that he was allegedly assaulted by.
And did he tell you when this assault took place?
Approximately 3:30 in the morning.
And this was around 2 in the
2 in the
afternoon.
afternoon, yeah. He had gone home, he got a ride with some unknown female, and then
And did you examine Mr. Lasowski?
I did.
And what were the extent of his injuries?
He had multiple facial contusions and lacerations, as well as posterior scalp contusions, and multiple contusions to his back.
Were the injuries that you saw upon your examination consistent with an assault with a weapon?
It was consistent with being hit with something, correct, yes.
And your observations of Mr. Lasowski, did he appear intoxicated to you?
At the time, he did not physically appear intoxicated to me, no.
Did you perform laboratory analysis of blood when he was in the emergency
I
department?
did.
And did that indicate that there was a blood alcohol level?
It did. His blood alcohol level was 98.
And so in the criminal justice system, the blood alcohol levels are a little bit different from the system that you use. Do you know offhand what a 98 would be in driving terms?
An 80 is considered the legal limit,
So 0.08.
so it'd be just under a 0.1.
Okay, thank you, Dr. Rooney. And what was the course of your treatment while Mr. Lasowski was in the emergency department?
The initial was to get a head CT, but as we further examined him, we noticed significant other injuries to his back. At that point in time, I switched over and did a full trauma panel on him as a trauma activation. So I got head, C-spine, maxillary facial CTs, as well as a chest, abdomen, and pelvis, and that's when I got the full blood work for analysis for trauma analysis.
And what injuries, if any, did the radiology indicate?
The radiology indicated multiple contusions, as what we found on the physical exam, and there was a nasal bone fracture at the time.
Dr. Rimley, I'd like to show you what's been previously admitted as people's exhibits 1 through 9 and ask you if these photographs are consistent with what you saw during your examination. This is people's exhibit 1. Can you describe, if you're able to see it from where you are, what we're looking at there?
You're looking at the top portion of his scalp, where he had multiple lacerations. I believe there was 3 total.
How did you treat that, Dr. Rimley? How did you treat that?
I stapled them shut with multiple staples. I also extruded a hematoma that was on the top of his head, which is just basically a blood clot and a pooling of blood. So you get the skin layers back together. That's pretty common with this type of injury.
I'll show you people's exhibit 2, Dr. Rimley. What do we see there?
Those are, again, contusions around the face, over the bridge of the nose. You can see the ecchymosis underneath the eye. Obviously, the injuries happened well before he got to the emergency department.
And for the jury's benefit, ecchymosis means?
Bruising.
Thank you, doctor. Here's people's exhibit 3. I don't know that you'll be able to see anything, can you?
Knowing the patient and treating the patient, I do know there's a laceration back there where I stapled shut. Like I said, there was 3 that I total stapled shut.
Here's people's exhibit 4, doctor.
Again, you're seeing the frontal facial bones. You'll see over the nose and the cheekbones. You can see where the redness is and the swelling. That's blood pooling. The swelling of the nose, you can see ecchymosis or bruising over the bridge of the nose and an abrasion. That would be consistent with the being struck with an object, as well as where his nasal bone fracture was. And then you can see across the left side of the forehead, again, more bruising and abrasions, which would be consistent with being struck with an object.
Doctor, here's people's exhibit 5.
Yeah, that's as we started to explore more, and that's when we realized that the significance of his injuries were more than what we were thought initially. And what you're seeing there is where it looks like an object with legs and, you know, a certain width struck him across the back multiple times. And you can see the bruising associated with that.
I'll show you people's exhibit 6.
Again, more of the strike indications across the back.
People's exhibit 7.
Again, more of the same.
People's exhibit 8.
Again, more of the same.
And finally, people's exhibit 9.
And then you're seeing a complete back wound where you can see multiple contusions consistent with being struck with an object.
And so, Dr. Rimley, were you able to treat Mr. Lasowski at McLaren Thumb Region, or did he have to be transferred to another facility?
No, fortunately, his injuries allowed me to treat him in the emergency department. There was no significant trauma in the sense it needed to go to a trauma center. So I was able to treat him with laceration repair and pain medication.
Thank you, Dr. Rimley. I have nothing further at this time.
Cross-examination, sir.
Doctor, you say contusion, so was it bruises on his back?
Yes, sir.
There was no broken bones to his back
Not to his back, no, sir.
or to his shoulders?
Not to his shoulders, no, sir.
The only fracture was the nose, correct?
Yes, sir.
And is that possible to be broken by a punch?
Absolutely. Like I said, struck with an object. I have no idea what object hit him there.
It wouldn't have to have been the alleged bat, it could have been a fist
Whatever they, yeah, it could have been a fist, it could have been anything.
or
Yeah.
wrestling with someone and they fall through a kitchen table. Is that possible?
Absolutely possible.
And he said he didn't appear intoxicated?
No, he did not appear intoxicated to me at the time.
All right, but he would have been about a 0.1?
Correct.
Under a 0.1? And obviously you weren't giving him alcohol in the emergency.
No, sir, don't do that.
So he would have been much higher earlier.
Theoretically speaking, yes. To have a 0.1, typically the average human will excrete alcohol at 0.2 to 0.25 units per hour.
0.02?
0.2 and 0.25, yes, sir, or 25.
So I mean, if this happened 10 hours later, I mean, he was closer to 0.3.
Objection, that calls for speculation.
I couldn't tell you that, sir, because I don't know when he drank and when he didn't drink.
Objection sustained.
Okay, sorry. You just know rule of thumb is about that.
Rule of thumb when I'm clearing patients that have known alcohol when they come in, and it's a set number, but, and then I can know after so many hours based upon that equation, then I can safely clear them alcohol, but it doesn't tell me when they last drank. It doesn't tell me if he went home and drank in this house that morning. And out of shape for the altercation. So I have no idea when he drank. I can just tell you that, yes, when people do come in that are significantly drunk, that's about how fast it comes down.
Okay. And was he kept overnight or was he released that day?
He was released that day.
No redirect, Your Honor. We'd ask Dr. Rimley be excused.
Any objection? Doctor, you may sit down. Thank you. Thank you. You're next.
People called Detective Sergeant Kevin Knoblauch.
Sergeant, please.
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Thank you, Your Honor. Good morning. Please state your name and spell your last name for the court reporter.
Excuse me, Kevin Knoblauch, Knoblock.
And sir, how are you employed?
At this time, I was a detective sergeant with the Bad Axe Police Department, charged investigations.
And were you working in that capacity around March 16th of 2022?
Yes,
How did you become involved with this particular Wichert-Lasowski assault case?
initially I was contacted by Road Patrol on the day of the incident for guidance, Officer Guza Emming, but eventually was turned over to me for further investigation.
And is it fair to say that you would have reviewed the report from Officer Emming?
That is correct.
And why did your involvement with the case begin on March 16th of 2022, when we've heard testimony that this took place back February 2.5 weeks earlier?
The victim had contacted law enforcement approximately a week later, and between setting up telephone calls and meetings with the witness and victim, it was March 16th.
And so we heard testimony from Officer Guza that Mr. Lasowski was not cooperative in the ER. Did that change when he spoke with you?
It did.
Okay. After your interview, well, I should say, did you ultimately interview Mr. Lasowski?
I did, yes.
Okay. And after your interview and continuing investigation, were you able to determine when the assault took place?
Yes.
And when was that?
It was in the early morning hours of February 26th.
of 2022?
of 2022, yes.
And also similarly, through your interviews and investigation, were you able to determine where this assault took place?
Yes.
And what was that address?
It was 319 North Stanley Street in the city of Bad Axe.
Is that in Huron County?
Yes, it is.
Were you able to determine throughout your investigation and your interviews whether a weapon was used in the assault?
Yes.
And at the conclusion of your initial interview with Mr. Lasowski, were you able to identify a suspect in this assault?
Yes.
And who was that individual?
The individual that the victim identified was the defendant, Connor Wichert.
And do you see him here in the courtroom today?
Yes, I do.
Can you please point to him and tell me what he's wearing?
He's sitting in the middle next to his counsel. He's got a maroon shirt on, tie, and coat.
Would the record please reflect that the witness has identified the defendant?
You should.
Thank you. And so, Detective Knobloch, then, did you find Mr. Lasowski credible throughout your interviews with him?
I did.
What was the next step then in your investigation after interviewing Mr. Lasowski?
I interviewed a witness that was identified at the house,
And who was that witness?
Morgan Weisenbaum,
And when did you interview her?
on the 16th of March.
And where did you interview her?
I interviewed her at the Bad Axe City Police Department.
And she arrived there, how did that arrangement work? Did you call her and she came, or how did that work?
I obtained the telephone number for Miss Weisenbaum. I called her, I think it was the day before, a couple days before, and I made arrangements to meet with her at our office for the interview.
And after completing your interview with Ms. Weisenbaum, did you find her to be credible?
Yes,
Based upon your entire investigation up to this point, did your identification of a suspect remain the same?
yes,
It was still the defendant, Mr. White.
correct.
Now, after your interview and as a result of your investigation, what type of weapon were you looking for?
Based on the interviews with the victim and the witness, I was looking for a approximately 3-foot long object that was narrow, resembled what was described as an oddly shaped bat. It was yellow in color with gray tape wrapped around the handle.
And so with that in mind, what was the next step in your investigation?
I sought a search warrant.
And what is this search warrant for the jury's benefit?
A search warrant is a legal document supported by an affidavit of facts, information, belief. It's a court order signed by a judge that allows law enforcement to enter on a premises to seize a certain object.
And what premises was it that you were seeking to search?
I was seeking to search 319 North Stanley Street.
And who lives at 319 North Stanley Street?
The defendant, Mr. Wichert.
Did you execute that search warrant?
I did, yes.
And when did you execute the search warrant?
I executed the search warrant on March 24th of 2022.
And was the defendant present at the execution of the search warrant?
He initially wasn't there, but he arrived shortly thereafter. To answer your question, yes, he was there.
And so how did you proceed then with the execution of the search warrant? You said you were looking for a specific item. What did you do next?
I met with Mr. Wichert in the yard outside his residence. I informed him of the forthcoming search warrant, and we went into the house. It was a soft entry, and Mr. Wichert walked over to the living room area of the house, retrieved this item, and handed it to me.
And describe the item that you recovered, Detective Knobloch.
The item I recovered was a approximately 3-foot long, yellow and chrome colored, it's a training baseball bat or softball bat is what they're referred to.
May I approach the witness, Your Honor?
You may.
Detective Knobloch, I have what's been marked here as People's Proposed Exhibit number 10. Do you recognize this item?
Yes, I do.
Do you recognize the evidence tag that's attached to that item?
Yes, I do.
Is that the item that you recovered following the execution of the search warrant at the defendant's home?
Yes,
People have moved for the admission of proposed exhibit 10.
Objection.
People tend to.
And throughout or as your investigation continued, were you able to definitively determine what that object is?
Yes.
And what is it?
It's an Easton training bat. It's used in baseball, softball for practice. It's approximately 2.5 pounds.
Was, based upon your investigation as well as your interviews, was that item consistent with the injuries that you saw of Mr. Lasowski?
I would say it's consistent.
Thank you. I have nothing further at this time, Your Honor.
Cross-examination.
Sir, you went to the house at 319 Stanley,
Yes,
and that's where this incident allegedly took place.
that's correct. Yes.
Did you take any photos of the layout?
No, I didn't.
Did you look for any blood, spatter, DNA?
No, I didn't. It was after the fact.
Okay, so you went there just to get the bat.
The weapon, alleged weapon involved in this. Yes.
And Connor immediately handed it to you.
He's cooperative. Yes, he did.
He went and he got it right for you, didn't fight your retrieval of it.
No, he complied, and yes, he did.
Did Mr. Lasowski tell you how the assault happened?
Yes.
Did he ever say how it ended?
I don't believe he did.
Did he say there was more than one assault that took place?
There was 2.
He said there was 2.
Yes.
Did he ever make any statements about him taking the bat from Connor?
He did say that initially.
So he said that initially. Did he change his story on that then?
He made that statement to another officer prior, but he did recant that later. Yes.
All right, so it was Officer Hemming,
It was, I believe it was Sergeant Anderson at that time.
Sergeant Anderson. He said you took the bat from Connor, but he told you that no, someone else took the bat.
Yes.
And Sergeant Anderson, he was the second officer to interview Mr. Lasowski, right?
Correct.
That was after he decided he wanted to go forward with the case.
Yes.
So it wasn't, the first interview was Officer Hemming, who he didn't want to give any information to, and then he contacted the department, and Officer Anderson is the second officer to go see.
Yes.
And then you would have been the third.
Correct.
And you do your interview of him on March 16th,
Yes.
so 20 some days after the incident.
Just under, yes.
No further question.
Thank you. Redirect.
No redirect, Your Honor.
Sergeant. Well, look at that for time. Members of the jury, we are going to take our noon recess. We're going to take approximately an hour off for lunch. When you leave, you can go anywhere you wish for lunch. Again, if anyone approaches you or anyone wants to speak with you or you want to speak to anyone else, you can do so, but you cannot discuss any aspects of the case. Not even to look up any aspects relative to the case, because again, you are only to decide this case based upon the evidence presented here in the courtroom. As I said, you go anywhere you wish, and I'd like to have you back in the jury room no later than, we'll make it 1 p.m. We'll begin approximately 1:05. Hopefully things continue working well. And when you leave, go anywhere you wish. When you come back, don't hang out, please, in the waiting area. As soon as you get back into the building, go right to the second floor, room 207, the door behind me, not the one with the scales of justice, there's one behind that yet. There's that little doorbell, hit that doorbell, it'll alert us that you're here. You'll hear a chirping sound. Once you hear the chirping sound, that means the lock is disengaged, grab the handle, and we'll escort you right into the jury. We'll take our new recess, all rise for the jury.